Good evening. Every Tuesday, we do bring in immigration updates live from Houston, Texas. Along with me is my business partner, Rebecca Chen. Rebecca, what do we have today to discuss?
Yeah, so in light of another wave of recent layoffs in the tech sector and elsewhere, we'll discuss what to do if you lose your job while you're on a non-immigrant visa, having a plan B, a backup plan, so that you know exactly what steps that you'll take once you are notified of a layoff, so that you're not caught off guard and scrambling for what to do if you do unexpectedly receive a termination notice. We'll also discuss the legal implications of a DUI for immigration purposes, how the visa gets canceled, what that means for your status in the US, and what you need to disclose to immigration. We'll also discuss remote work compliance. A lot of, with a lot of the workforce now working remotely or in a hybrid situation, especially on H-1B visas, we'll discuss what the requirements are to maintain compliance and to avoid common mistakes that we see. And kind of along those lines, we'll also discuss audits of employer sponsors, site visits, the increase in those FD&S visits that we've been seeing this year and how to prepare for them.
Okay, first thing is about the plan B when you lose the job. There are so many people I speak with, when they lose the job, they always think that they are the most important person in the world. And without them, the entire company, the whole fan companies don't work because of them. I don't know how they think, but they do think. Now, I definitely want everybody to have a plan B. We have seen a lot of layoffs recently in tech sector. It could be that artificial intelligence, it could be the immigration pressure the Trump administration is putting on the companies, so that if they are laying off people, they are laying off more H-1B people than compared to previously, because previously they may be laying off people who are not talented, who are not working hard. Right now, they may be looking forward for letting people go who are non-immigrant visa people, even if they are performing very good. So everybody needs to have a plan B. What are you going to do? I want everybody to discuss with their families, with your spouse, to discuss, if we lose the job, what are we going to do it? If both people lose the job, if one person is the only person who loses a job, what is the plan of action? Now, of course, B2 should be one of the things that you can consider if you don't have the H4 option. Let's say if both people are working and one person loses the job, definitely the easiest option would be the second person moving onto the H4 job. What if only one person is working and he loses the job? What if the two people are working, two people are laid off at the same time? Definitely B2 is one of the option where you can stay in United States for up to 60 days. And I'm sorry, up to 6 months you can stay in United States, and you can then move on to a different company. Also, F1 is another option that you can consider, where people can move on to the F1 student visa and upgrade their skills in United States and get back to the job. Also need to look into if they want to consider to going back to the home country, which was an easy option until this $100,000 memo came, $100,000 executive order came in, where anybody who's filing an H-1B could be imposed $100,000 if you are outside the country. So that's a thing that you need to consider before you move out of the country. Now, everybody knows that they have a 60-day grace period, assuming that your H-1B validity is still there. Let's say you get laid off on November 25th, you have up to 60 days, that is up to January 24th or so, you have time for you to find another job if your H1 validity is there. In that 60-day period is when you are going to look into finding another job. Easy, that's first thing. Move to H4, that's the second thing. Move into B2, that's the third thing. F1 is another option. You may want to consider even leaving the country and coming back later on, but that's going to cost the new company $100,000 unless some things changes. Now, you need to also have a plan with what are you going to do with the house? What are you going to do with the cars? What are you going to do with all the household equipment? How are you going to handle that? Do you have plans for it to transport any of those things? Do you have plans to dispose of the house? Do you have plans how you're going to handle all these things. Is your family prepared for it? What about the school structure in United States? All those things in United States and back home where you're going to leave the country. I want you guys to have a plan B before you get laid off. Don't tell me that you are the most important person in the company and you can never get laid off. Steve Jobs got fired, to my belief, or let go as the CEO of the company of the Apple, and that can happen with anybody, though. So please consider it, have a plan, and then go. And when it happens, then it will be easy for you to transit to the plan B. Rebecca, you have any thoughts on it?
Yeah. So basically, make sure you file something before the end of your 60-day grace period. The I-539 for the B2 can be filed, or the H4 or the F1. They can all be filed online. So if you are, in the interview process and are potentially waiting on some job offers, but it's a matter of, it doesn't look like the application will be filed, the transfer application will be filed within the 60 days. You can give it a little longer and just plan to file the I-539 even in the last week of your 60-day grace period. That's okay, because the advantage of filing online is you get the receipt notice immediately once you file the application. And that is your proof of authorized stay in the US that you can then provide to the new company to file your change of status back to the US, change of status back to H-1B if that job offer does come through.
Rebecca, if somebody has a DUI arrest, though, now according to law, though, you are just a suspect unless convicted, but yet you get a visa revocation from the consulate saying that your visa has been revoked. Can you tell me the circumstances, how the DUI, if somebody's arrested, how the things will work?
Yeah, so if you are arrested for DUI, even if you are not convicted, even if the charges are later dropped and everything is discharged, just the DUI arrest, it causes the consulate abroad that issued your most recent visa stamp in your passport, it causes that consulate to issue what's called a prudential revocation. So somehow the State Department that manages the consulates, they seem to have a pretty good access to state databases, law enforcement databases, excuse me. And they see when someone who applied for a visa through them got arrested for a DUI. If that's the case, they issue what's called a prudential revocation. So it doesn't even require you to be found guilty or convicted. The prudential is that it means that they're doing it to be on the safe side, because if you are eventually convicted of DUI, that's a ground of inadmissibility against you for immigration purposes. It's actually not under the criminal category of inadmissibility grounds. It's under the public health grounds, which is that if you're at risk of being considered a public drunkard or a habitual drunkard, you're not allowed to be admitted to the US. And so to be on the safe side, they prudentially revoke your visa, which means the visa stamp in your passport is canceled. You cannot use that visa for travel. The next time you step outside the US, you would need to go for visa stamping again at a consulate, even if the visa in your passport is unexpired. Usually people do get an email from the consulate that notifies them of the prudential revocation. Sometimes they do, sometimes they don't. If they don't, I would still assume that your visa is revoked for those purposes. That doesn't affect, though, your status in the US. Your non-immigrant status in the US, if you're in H-1B status, for example, is not affected as long as you don't depart the US. You're still authorized to work. You're still authorized to be in the US according to your I-797 approval notice and your I-94. And so in that case, you just need to seek the advice of an attorney. And definitely before you travel, get advice from an attorney on the consequences, because most likely the visa stamping will be very challenging the next time you leave the US. So it may be that you need to rethink traveling internationally for quite a while until you're prepared for potentially a long wait time at the consulate the next time you go. Usually what they do, if you do go to the consulate, is they'll refer you to have an evaluation done by a panel physician. You can't have that evaluation done in the US. It has to be done in the country of the consulate where you're applying. And then that evaluation, if the physician determines that you are not a habitual drunkard or, basically not a substance abuser, they will recommend to the consulate, and the consulate can still issue the visa, but it can be very difficult. We definitely would not recommend going for visa stamping if you've had a DUI under this current administration. Even very straightforward visa stamping right now is difficult under the current administration. So definitely seek advice from an attorney before you leave the US. And then going forward, even if your actual criminal court case is entirely dismissed, if you get probation and it's considered expunged and your criminal attorney tells you it's as if it didn't happen, it's like it doesn't exist. For immigration purposes, you still need to disclose it, no matter what the outcome was in the criminal court case. On the DS-160s going forward, on I-539 applications going forward, on I-485 applications going forward, anytime they ask about whether you've ever been arrested, charged, cited for any sort of criminal violation, you do need to answer yes to that question and disclose the details of it, even if in the actual case it was dismissed and nothing happened.
Next issue is remote work. Can people work remotely in H-1B? Definitely, it's allowed to work remotely. After COVID, we have seen a lot of people working remotely. The main question that pops up is that still you need to have an LCA where you are located at. For example, if you're working in Florida and you are working in Tallahassee, Florida, you must have an LCA. If you're working in an apartment or you're working in a house in Tallahassee, Florida, you must have an LCA from that particular location. Now, if you were to move in Dallas, I'm working remotely. Who knows where I'm working? So do you need an amendment if you move to Dallas? Absolutely, you need it. And you need the amendment to be filed before you move into Dallas, not after you move into Dallas. It's before you move into Dallas. Now, people say, how do they know it? First of all, guys, you write the programs. You know how the programs are written nowadays to detect where you are. There are so many different ways to detect it. Second thing is that FDNS now is coming very frequent to visit. They go to Tallahassee, please. They check, knock the door, tick, tick, tick. Mr. Subarao, are you there? Oops, not there. They will call Mr. Subarao, where are you? And if you say that you are in Dallas, of course, which you are going to say you're in Dallas, then definitely they are going to revoke your H-1B because you worked unauthorizedly in Dallas. And here is the problem. Previously, there are ways where we can send you out to do a consular processing, get a H-1B stamped and come back. And we have fixed so many of those things. Now, the same mistake is going to cost your company $100,000, which they're not going to pay. We haven't yet found a company that is willing to pay $100,000 yet. Now, if you're that worth, but still, you don't want to waste $100,000 of the company. So please, this is very important now. Every mistake or any mistake can cost you $100,000. So it is better that you take care of the things way before rather than later on. Any other common mistakes people should avoid in remote working, Rebecca?
That's the main one we see, is moving without notifying USCIS or notifying your employer even that you've moved and are working from elsewhere in the US. So you need to make your employer aware, make sure they're filing the H-1B amendment before you make that move to your new work location. It does go with kind of our next topic of site visits. So FDNS officers will come to a residence. They will go to a home if that's the address that's listed on the LCA and the I-129 form, and they will, ask to come inside. They do need permission, but again, if the participation in the FDNS site visit is no longer voluntary, by having the H-1B petition filed on your behalf, you agree to participate in follow-up visits by FDNS. So you are kind of obligated to admit them into your home if they ask to see your workstation, if they ask to see examples of your work. If in your application your employer said that they manage you remotely, through Zoom calls or phone, they'll want to see that you have a webcam and some way to um, correspond with your manager and an actual workstation. So be prepared for all of that. The percentage of FDNS site visits and verification emails from FDNS has definitely increased this year under the current administration.
Are you seeing any audits going on? How do they come in though? Do they have a particular questions that they will ask, Rebecca?
Yeah. So the tone of a lot of the questions that we've seen, or the theme, seems to be trying to ascertain if the job duties that the H-1B beneficiary is performing are aligned with the wage level that was selected on the LCA. So if you've been with the company for a few years, if you've had an extension filed with that company, but the company still listed you as a level 1 wage on their most recent LCA that they filed on your behalf, an FDNS officer is going to be interested in that. They're going to be asking for proof of your job duties. They will reach out to the end client if you work on a project for an end client to ask the people that you coordinate with there for corroboration of what your job duties are. That's also part of the new regulation this year, is that evidence of specialty occupation work can be the USCIS can ask for corroboration by the end client. If you're working on a project for the end client, they can ask the end client, what are the normal minimum requirements for this job as far as education and experience? If the end client says that, someone performing this type of work on this project would normally have a bachelor's degree and 5 years of experience, but your employer categorized you as a level 1 wage on the LCA, that's inconsistent, that's in conflict, and that could result in further investigation by DHS.
Anything else, Rebecca, before we go to questions?
Nope.
I have an interesting question from Lalita, and she has applied for a change of status, and it's been pending for more than 6 months. Is it a problem that her change of status is pending for more than 6 months? Is she in trouble? I'm assuming either you moved from F1 to H4 or probably H1 to H4, or if it's been pending for more than 6 months, absolutely you are not in trouble. You can stay in United States while the pending change of status, which I'm assuming it's probably is H4, is pending, and you should not have any problem in staying in United States. She also pointed out that in California, she heard that ICE has detained some people whose change of status or her extension of status is pending. We have not heard about it, though. We have not. Now, there are ways the ICE can verify whether your change of status is pending. They will check whether your change of status is pending. We haven't heard anything like that any detention has happened for the people whose change of status is pending or whose extension of status is pending. No, we have not heard it at all, though. There are a lot of rumors that are flying in, so we want you to tune in. If there is anybody that comes in, we do give a free consultation for them. If there's something that is odd about it, and we don't want to speak with the intermediary, though. We want to speak with either directly with that guy or the brother or sister or cousin of that particular person. Oh, my friend got into trouble. Can you speak about that? I know for sure. No, I would like to speak about with that guy. Now, if the person is in detention, though, we don't mind speaking with the immediate relatives of that particular person. Even if they are in India, we don't mind speaking with them. Now, there are a lot of times when people have some other issues, though, and they're being detained, they don't let you guys know what the actual truth is. We will come to know, Lalita, what the actual truth is when we speak, because they do speak with us all clearly, though. So if your change of status is pending, you do not live in fear. You're perfectly okay. And if you have any travel plans within the United States, you can travel using your passport, and the change of status receipt notice. Absolutely not a problem for you, Lalita.
We have a question on whether an H-1B that moves to B2 status and then changes status back to H-1B again, is that subject to the $100,000 fee? No, it's not. So changes of status within the U.S., extensions of status in the U.S., transfers, amendments, as long as you are physically in the U.S. in valid status at the time the H-1B petition is being filed, that H-1B application is not subject to the $100,000 fee. So that's why B2 definitely is probably going to be a more necessary option for people now rather than relocating back to their home country if they don't find a job after 60 days. Because if you can manage to stay in the US in valid status, then you're not subject to the fee when you try to move back to H-1B.
Ajay Kumar has this question that he lost his job. He 15 days ago, he has 45 days still left. When should he file the B2 or B2? You can file on 56th or 57th day. Now, we normally tell people go file very early though. But in this case though, since you can file the B2 application online itself, you can file it online itself. There is one caveat. Some people will say that there is no H1B from H1B status. It always puts H1B1. It doesn't give an H1B option. You can pick H1B1 option. Not a problem. We have done for hundreds of people. I've never had any problem. So you can pick that one. You can file the change of status. So you don't have to hurriedly file right now because Ajay, you may even get a job in these 40 days and you may find a company to file a H1B, then you would have wasted this B2 money. So I would rather wait until 50-50 and file it online. That is the best course of action.
We have a question about international travel for someone who has a valid H-1B visa stamp with the same employer, stable job, no changes. Does travel in December safe, or should there be any issues at reentry? In that situation, generally you are okay. If you already have the visa stamped in your passport, it's unexpired. You just need to make sure you have a recently dated employment verification letter from your employer when you're re-entering the US, copies of your recent pay statements. Maybe try to time your flight back to the US with like a normal weekday business hour in case they try to reach out to your employer to verify that you are working for them. That has been happening occasionally, not all the time, but occasionally, and give the person who signed your employment verification letter a heads up that they might be contacted by CBP on this date. Generally, that should be fine. We haven't heard of many issues. The main risk is still that, with the $100,000 fee proclamation, between the time that was announced on a Friday afternoon and the time it went into effect at like midnight on that following Sunday, it was barely 30 hours. And so at that time, before it was clear what the consequences or implications of that fee proclamation was, there was kind of all sorts of incorrect information going around, widespread panic, and people were rushing to try to return to the US before it went into effect. So there is always, even if you have a valid visa stamp, don't need to visit the consulate when coming back. That's kind of the main risk of traveling, is this administration can at any time drop another bombshell with little notice that, if you need to return quickly, will you be able to quickly enough? That's the only thing to kind of consider for travel in that case.
Alanis asked this question that on advanced parole, is it safe to travel outside the country? I don't have the H-1B. Absolutely not a problem. We've never seen any problem people traveling in advanced parole and coming back. In some of the airports, they may take you to a small room because the officer might not have the proper equipment to handle the advanced parole. It may take an extra 15 minutes, but we have not seen any problem whatsoever at all for advanced parole. Even in the past 3 months, we have never seen any problem.
We have a question from Suraj, who says he has a remote job in the US, received another job offer from an Indian employer, and asks if he moves back to India, is it safe to work for the H-1B employer and the Indian employer at the same time? So that's fine. So the work authorization rules are still very much attached to where you physically are in the world. No matter where the employer is, and no matter how you work for them remotely or in person, your work authorization is based on where you are physically sitting. So if you are physically in India, as long as you are authorized to work in India, which I assume you are, then there's no problem working remotely for a U.S. employer. As long as then it's on the U.S. employer to work out, how they want to do that arrangement. If it's going to be long term, are they going to just change you over to a contractor situation, or and then how will you do your tax reporting in India? That's kind of a different question. But for immigration purposes, work authorization purposes, there's no problem with that. You do need to consider, though, that if you, again, in light of the $100,000 fee proclamation, if you do leave the US and work abroad, if you want to come back in the future, another company would have to, either your current H-1B employer or another employer would need to file another consular processing application for you once your current I-797 approval notice expires. And if the fee proclamation is still in effect at that time, there's a $100,000 fee attached to that application. So either if you take this route, you may want to plan to come back before your current I-797 expires so that you can have an extension of status filed, or plan to remain abroad until, wait out this $100,000 fee proclamation until it's no longer in effect, which could be not until this current administration is out of office.
Srinath has this question. If I change an apartment or a house within drivable distance, let's say within 20 miles, do I need to file an amendment for the H-1B before I move into the new apartment? The answer is no. If it is within 20 miles, you absolutely don't have to file any amendment. One other gentleman has this question. What if I travel to my cousin's home and I intend to stay there for 10 days? Do I need to file an amendment? No. If you're just traveling there and you're going to come back, though, and that especially for 10 days, I don't see any problem. You don't need to file any amendment for that particular location. Absolutely not needed.
We have a question on if you get an AC-21 one-year H-1B extension with your current employer, can you switch to a new job after that if your H-1B max out is in October 2026? So it depends. Technically, yes, you can switch employers. But if your 7th year extension that you are applying for now is based on the pending perm filed by your current employer, if that perm and I-140 don't get approved before you move to the next employer, then that company could withdraw the perm and the pending I-140 once you leave. So if you think your current employer is going to withdraw the perm and or I-140 once you leave, that removes the basis of your AC-21 7th year extension. So the perm or the I-140 that gets you the 7th year or the 3-year extension beyond the 6-year limit, it doesn't need to be the company that's filing your H-1B. But if you leave this company and they, as a result, withdraw your perm, then you don't have anything to request a 7th year extension with the new employer. There won't be enough time for the new company to file the perm for you at this point. So yeah, it depends on whether you think that company will withdraw it if you leave.
Supraja Ravla has this question that is it suggested to do upgrade to premium processing? My H-1B petition has been pending for 5 months. Is your H-1B already expired, or is it not expired though? If your current H-1B has already expired, then there is no point in doing a premium processing right now, because if your denial comes in, you will have to leave the country. So that's not needed if the I-94 has already expired. But if your I-94 has not expired, though, I definitely want you to do premium processing. I want the result of your H-1B to come before your I-94 expires, because if your I-94 expires, if any chance a denial comes in, you are out of luck, because then you have to leave the country, though. But if the denial comes in before the I-94 expires, then you have an option. You probably can refile the H-1B and get another approval. So that's the reason why we tell get the result before the current visa status expires.
So this person is waiting for company A to complete the H-1B transfer they filed for them, and now Company B wants to file a transfer for them also. Do they need to wait for pay stubs, I think, from Company A before Company B can start its transfer process? It depends on if you've joined Company A yet. So if you are still with your original employer and you have not yet joined the payroll of Company A, then you don't need to wait for pay stubs from Company A in order to have Company B file its transfer. But if you have joined Company A already and that transfer is still pending, you can have Company B file a transfer for you, but in order for Company B's transfer to be approved, USCIS will probably want to see that Company A's transfer gets approved. And if Company A withdraws their pending application for you before it gets approved because you left the company to join Company B, then Company A's transfer might not be approved, which means Company B's transfer probably won't be approved. So, it really depends on which company you're working for now, whether you need to wait on the timing. If you have joined Company A, it's best if you can upgrade the transfer to premium processing, get it approved, and then have Company B file its transfer.
Rahul 2005 from YouTube has this question. H4 and EAD renewal is pending. Existing visa validity expired in September and still waiting for the extension of the H4 and EAD approved. Is this considered to be out of status? I-94 is already expired. Absolutely not. It is pending status, so it is not considered to be out of status. The only time it will be considered out of status is if by any chance the extension gets denied. Then from the time of the denial, it would be considered that you are out of status. So right now you're safe. I don't see any problem with it.
Chen Lender is on STEM OPT. His H-1B consular processing case is pending, and he's planning to travel in February 2026. And he's asking if the $100,000 fee rule will apply. It should not if you were selected in this past lottery in March 2025. If you were selected in the March 2025 lottery and then the company filed the H-1B petition for you by June 30th, 2025, even if it's still pending now, it's not subject to the $100,000 fee rule. The $100,000 fee only applies to petitions filed in consular processing that have a received date on or after September 21st, I believe, 2025, basically that weekend when it was first announced. So even if you're going for visa stamping in February or anytime next year, you will not be subject to the fee because the original petition was filed prior to September 2025.
Question that came from Ajay Kumar. He was affected by the layoff right now. His I-140 has been approved and his employer is not going to withdraw the I-140 application. When he moves to the new employer, do you recommend the new employer to apply for the, apart from the H-1B transfer, should they file for the labor and I-140? The first question here is that if the I-140 has been approved and it's not been withdrawn for 6 months, though, 180 days. And after 180 days, if it's withdrawn, it doesn't have any negative effect. So people are under the assumption that it cannot be withdrawn after 180 days. It can be withdrawn, but it won't have any negative effect. So once it passes 180 days, that I-140 belongs to you technically. You can use that I-140 to file the H-1B extension from company A to you can move to company A to company B. You can use that company A's I-140 approval to move from company B to company C. You can use company A's I-140 approval to move from company C to company D. You can use company A's I-140 approval to get the H4 EAD for your spouse on company D's H1B and H4. You can use that date porting to company D, even though company B and company C never filed an I-140. You can port the date to the priority date of company D. Now, do you suggest filing the I-140s by the new company? Depends on the priority date, though. If your priority date is 2018 or afterwards, No hurry because it's not becoming current soon. There is no hurry for you to file the file for the labor and I-140 because you only time you would need an I-140 approval from the new company is when the dates become current and you need to file the 485. You need to have that labor certification and I-140 from the current company. Since if you're from India and your priority date is after 2018, at least in the next 5 years, it's not expected to become current. So there is no hurry for you to file the labor and I-140 with the new company.
SGN says that they're on H-1B working on an end client project remotely and asks what are the situations where an H-1B amendment is needed? If there's a change of address, change of client, moving from remote to hybrid with the client. So in order to properly maintain your H-1B status, the rule is that if your physical work location changes to an area outside your current MSA, Metropolitan Statistical Area, basically the metro area that your current LCA is approved for, an amendment is needed. So if your current approved H-1B petition, the LCA lists your work location as your home address in Houston, Texas, and you're going to move to Sugar Land, Texas, which is kind of a suburb here of Houston. An amendment is not needed in that situation, even though your work location, physical work location is changing, but because the address is within the same MSA as the original Houston work location, an amendment is not needed. And if you're not sure about whether the change in address requires an amendment, you can always make sure you notify your employer before the move happens so that they can check with the attorney and the attorney can look up and see whether it's a change that requires an amendment. So it is still attached to physical work location. If you're, again, and then if you're going from completely remote to hybrid, where you're partly working from home, partly working from the client's office or the petitioner's office, whatever that second work location is that's being added, if it's also within the same MSA as the work locations listed on your approved LCA, an amendment is not needed. So you can also add work locations within the MSA without needing an amendment. If the hybrid situation is going to add a work location that's outside the MSA, that will require an amendment. And then, so that's to maintain proper H-1B status. That's very important. Generally, if you're working remotely and your client project just changes, the project changes or the client that you're working on changes, but your physical work location isn't changing or it's not changing outside the MSA, typically an amendment is not needed. You are still maintaining H-1B status if you just move from a project with client A to a project with client B, all still sitting at your home. If the other employment terms remain about the same, if your job title, duties, salary are otherwise unchanged, and an amendment is not needed in that situation if you'll be remaining in the US. The only time an amendment is needed for a client project change is if you are planning to travel internationally and need to go for visa stamping. The consulate's requirement is different from USCIS's requirement in this regard. The consulate does want to see in the most recent approved petition the current client project details of the project that you are working on right now. So even if your home work location is not changed, if your client is changing and you know that you need to go for visa stamping soon, you do need to have your company file an amendment for you early enough so that it can get approved. And then you can use that approval notice to book your appointment and fill out your DS-160. So you really need to get that amendment process started quite early if you are needing to go for visa stamping, which we don't recommend anyway. This is not a good time to be going for visa stamping. Only in emergencies right now is our general advice.
A question that is coming from Richa is for, does your firm help national interest waiver? The same question is coming, does your firm help EB1C? Yes, definitely. But however, I just want you to make sure that you must be eligible for it based on your qualification, your achievements, and your publications. You must be eligible for the NIW or you must be eligible for the EB1C. We are not going to fabricate any of those things. We're not going to write articles for you. We're not going to publish anything for you. We are not going to do it. And there are some agencies that are doing it. We consider them as completely illegal, where I've known some of the agencies that are charging $40,000 to $50,000 to file for the EB1A category. And he told me that all they did, he just gave them the resume, and then they gave him the draft of the published to be published articles in professional magazines, and they paid money to publish these things, and based on that they filed the I-140 application. The I-140 got denied. Now, the problem with dealing with those fraudulent agencies is that you will be barred forever to come back into the United States. The reason is that paying money for publications, for judging people, judging other things, all those kind of activities are considered to be completely illegal. Referring to those kind of citations to get an NIW or EB1C is not legal at all. So it may be even fraudulent, and they may bar you forever to come into the United States. We have seen some of the revocations that have happened where they've been barred forever to come back into the United States. And we suspect that if you deal with these kind of agencies, you will get into trouble. Think of this thing. EB1C, our national interest waiver, is designed for talented people who are eligible for it, not the people where somebody else is going to write the things for you, somebody else is going to publish, else is going to judge the things for you, somebody else is going to have all that thing done for you. Then definitely you're not eligible for NIW or EB1C. Those people who are talented people, who are eligible, who think so they are marginally eligible also, you can consult our office. We will evaluate it. The person to contact in our office is Kareem in our office, Kareem Jivani, and Ryan Vick. These are the people whom you can contact on National Interest Waiver or EB1C.
We have a question from someone asking why some employers back off kind of, I guess, late in the interview process when they find out that you are in B2 status or that you have a pending B2. And they mentioned that there is a certain law firm that has kind of told companies that people in this situation are high risk. So it's true that the B2 policy, this practice of using a B2 change of status as kind of a de facto extension of the 60-day grace period, that was a Biden administration policy. It was introduced, I think, in spring 2023. And it was, this really only became an option because the Biden administration at that time said, specifically said you can use this as an option if you are still job searching at the end of your 60-day grace period. And they also said that another reason why a B2 change of status used to not be a very viable option is that when you are ready to change status back to H-1B, if the B2 is still pending, USCIS used to not touch the H-1B until the B2 was decided, which could take 6 months because there's no premium processing for a B2 application. And so practically, it didn't make that much sense because a new employer isn't going to want to wait like 4 to 5 months for your B2 to get approved in order to change your status to H-1B. The Biden administration policy basically said we're going to bundle your pending B2 with the new H-1B application and adjudicate both simultaneously so that you can be back in H-1B status within like a 3-week premium processing time that the company files the H-1B in. So that made it very useful and a very helpful option. And it's true that at the beginning of this year, going into this administration, we didn't know if USCIS would continue with that bundling policy because it's not a regulation, it's not even a memo. I think it was just a policy on its website, and so it is something that can very easily be changed by a new administration. They can just change their mind at any time to no longer bundle the B2 and H-1B if they want to. So we were observing it pretty closely going into this year to see what USCIS would do. So far this year, even though they archived the website that listed that bundling policy, so far this year, we've still been seeing that the B2 to H-1B strategy has still been successful. Sometimes we see an RFE here and there on the B2 application, but not very much. for the vast majority of cases, it is still the best option. It's a better option than leaving the U.S. If H4 is not a viable option and you don't want to switch to F1 status and go to school. So it is kind of, some companies may be being advised by their attorneys that because it is just a policy decision by USCIS and that it could change at any time, maybe that's why they are advising that people in a B2 to H1B transition, could be risky if USCIS changes its mind at any time. But it's not all companies. I just had a consultation this afternoon from someone in this exact situation who is considering offers from different companies, and one very big company, one very recognizable nationwide company, their attorneys advised he's not at the end of his 60-day grace period yet. It will be like in about a week or so, but was discussing with them, was upfront with them about his visa status. They know they don't have time to file the transfer within the 60-day grace period, and that company's attorney told him file for the B2 and then we'll do a change of status back. So there are companies out there with attorneys that understand that it's still a successful strategy for the most part right now. And in a lot of cases, it is the best strategy.
And the particular law firm that the gentleman named in here, we have seen them advising people. They have told people to advise to move to B2 and then move back to H1B. So maybe that particular lawyer might not be that familiar with this, but I completely agree with Rebecca that nowadays we are still getting the approvals from B2 to H1B, even though B2 is still pending though. Definitely don't see much problem.
Let's see. So there's a question about processing times for I-140s in regular processing, whether it's been faster recently. Yes, for some reason, we have been seeing faster I-140 processing times in regular processing recently. They've been like in 3 or 4 months sometimes, whereas previously it was like 12 months or more for perm-based I-140 filings in regular processing. So we don't know why there's been such a sudden decrease in the processing time for those applications. For NIW I-140s, the regular processing, I think, is still taking closer to a year. That has not decreased as much, the NIW processing time.
People were commenting about the San Diego incident where some of the lawyers there have reported that if the person has overstayed and they have applied marriage-based green card, even though they entered legally in United States, they were being detained by the ICE. Is this happening elsewhere? Definitely, we haven't noticed that happening elsewhere. If ever you have overstayed and you are now genuinely married to a US citizen, though, definitely I want you to contact an immigration lawyer to evaluate your things very carefully before you file an application with the USCIS. But no, we have not seen that incident happening across the board. Whenever we see some incidents that are very odd, that is only happening with specific district or specific area, and it's not happening across the board, though. We have seen the USCIS or the ICE correcting those things, though. Especially, we have seen notice to appear for the people who are in the 60-day gap period, especially in the month of June and July of 2025. And that has been corrected right now. We are not seeing the NTAs right now for the people who are in the 60-day grace period when the company has withdrawn the H-1B, though. So definitely that seems to be a very isolated incident at this point of time, but still, I want people to take the caution if you are applying for the marriage-based green card and you have some status violation.
Karthik was previously in H-1B status for several years, and he has been out of the U.S. since 2021 and is now a Canadian citizen and is asking, can he come to the U.S. using his passport basically as a visitor in ESTA and then apply for a change of status to H1? Will the $100,000 fee rule apply? Technically not, but I wouldn't really recommend coming in as a visitor and then planning to file a change of status to H-1B. That can be tricky. Technically, yes, if at the time you enter, you genuinely are coming in just as a visitor, have no intention to work, and then while you are here, before your I-94 expires, you get a job offer and the company files the change of status application for you. Your intention can change after entry, but the risk is always going to be that the government is going to be suspicious that your visitor and your intention at entry was not only as a visitor, that you came in at the time with the intention of changing to H-1B status to get around the $100,000 fee. My recommendation would be that since you have a Canadian passport, if your job is one that's on the TN occupation list, it may be a better idea to try to come in on a TN visa. And then once you're here in TN status, you could continue in TN status. Your TN would be issued for usually 3 years at a time. And then at some point during that time, the company can file your change of status from TN back to H-1B if you want to. And that application also would not be subject to the $100,000 fee. But that's kind of a less problematic route, because when you're coming in TN status, you're coming in with the intention to work. So there's no problem with the intent issue there.
Algorithm Warrior has this question. His previous labor certification salary is $200,000, and now new labor certification salary is $70,000. Do you see that as a problem? No, we don't see that as a problem. If the prevailing wage has been approved and you are getting that particular wage, and we don't see that as a problem. People change their jobs. They change from top to bottom, bottom to bottom. And I used to be the managing partner of Reddy Newman Brown, but I'm not right now. I'm just a regular lawyer in my own law firm that I founded. Emily Newman is the managing partner. Can that happen? Can people go down to higher to lower positions? Yes, that can happen. Nothing wrong with it.
Sid Mohan asks, if the H-1B wage increase rule goes into effect, will it impact existing H-1B workers at the time they're filing for their extensions next year? Will the new wage have to be forced on the LCA? So if DOL goes forward with its plan to increase the prevailing wages across the board, and we saw this happen under the first Trump administration, it actually did go into effect for a few kind of chaotic months. At that time, at least, what we saw was it did not affect anyone with an already approved certified LCA or anyone with an approved H-1B. And we expect the same would be true this time if they implement something similar. It would primarily affect any new LCAs that are initiated and submitted after the new prevailing wages go into effect. And there's a lot of reasons why, the increase will likely be, we expect that it will be challenged in court again, like it was last time. Last time it was put on hold by a court because it was challenged through litigation, and we expect the same would happen this time. Also, there are alternatives if it does go into effect for the period and your extension has to be filed while it is in effect. There are alternative wage surveys that your company can consider that are not the DOL prevailing wage surveys. So we have used those before, especially during that 3-month period during the first Trump administration when all of that was happening. Another thing that companies could consider is if your H-1B is expiring next year and they want to avoid the uncertainty of that, they could plan to file kind of an early extension by filing an amendment plus extension application. Generally, 6 months is the earliest you can file an extension of status application. But if they are amending some term of your employment, like increasing your salary slightly, which it probably has already increased somewhat from what was listed in your prior H-1B application 2.5 years ago. If your salary has changed a bit, if your job duties have changed a bit, they can file it as an amendment, which would allow them to file it right now. They don't have to wait for the 6-month mark, and they can request an extension at the same time. So you could potentially get an approval from, let's see, at this point, like May 2026 to May 2029. Yeah. So you could get an approval now, lock in that approval with the current LCA wage rates valid until May 2029. That should get us at least past the Trump administration, right? Yeah.
Ravi Malik has this question: is working full time on a remote job from the apartment or home, is that going to be a problem for H-1B stamping? No, the consulates are well aware that people can work remotely. We have not had any issues specifically on that issue. But I just want warn people right now who are going for stamping. Trump administration as such is not that favorable for the H-1B stamping for you to come back into the United States. Especially now they have an incentive. They stop you, then you will have to pay $100,000 to come back in a different company. So they have more incentive to stop you on coming back into the United States. So we strongly recommend to avoid stamping for anybody who is going outside the country at this point of time, because it's not a good time for people to go for stamping, for any stamping. Now, remote may not be a problem, but in general, we are seeing a lot of problems for the stamping though. One other thing that I have noticed that I want to tell people, though, I want to share the things because we do conduct daily Zoom calls. About 40 to 60 people does show up there. I answer about, when I'm answering the questions, normally answer about 25 people. And there it is more interactive. That means that you ask the question, you can have a follow-up question. Those kind of things are there. And the link is provided there. You can participate in it. It's been going on from past 13 years, every single day, every working day. We do have the Zoom call. You can, and with that exposure, what my advice to people are is that the artificial intelligence has done a lot of damage to the non-immigrant visa people right now. So, especially if you are leaving the country and you are going for stamping, though, we are noticing that people are losing the jobs because the companies are able to say, okay, I can live with this guy without for 30 days. That means that I can replace this guy. So when we have the pressure of the job, though, and you have this artificial intelligence coming into picture, though, and you're leaving the country, you go there and you lose the job, you are doomed. You can't come back because first, you don't have a job, you can't come back into the country, even though you have a stamping with that particular company. And you may be subject to the $100,000 if you try to move to a different company and trying to come back. So I urge people at this point of time, don't travel if you don't need to go outside the country at this point of time.
We have a question from someone whose H4 and EAD were filed along with their spouse's H-1B application. The H-4 and EAD were not approved at the same time as the H-1B in August. They're still pending, and they want to know, can they travel to get the updated H-4 I-94 in order to get the EAD auto renewed? Based on the dates that you've listed in here, I believe you can, because if your husband's H-1B was approved in August 2028, until August 2028, then I think your application must have been filed before October. October is when the H-4 EAD auto extension policy changed. So if your I-765 was filed prior to October 2025, then you can still get the benefit of the H-4 EAD auto extension, which means if you travel and come back with your husband's extended H-1B approval notice, you should be able to get the extended I-94 for H-4 status by CBP at the border, and then using that, you can get the EAD auto renewed. That is still available. The I-765 won't be denied if you depart the U.S. It will continue processing. The I-539 will also continue processing. They won't be abandoned. So that is still available to you, but I would recommend that you consult maybe with an immigration attorney first to have your receipt notices reviewed to make sure you are still eligible for the auto extension policy, because that just changed in the last 1 month or so. So depending on when your application is filed, it may still be available to you.
Anshuman has this question. I think so. That's been answered. Rebecca, I'm going to speak something, and then I want you to correct me. A lot of people are asking question. Now, the 540-day EAD rule is not there. That the extension is pending, especially for the in certain cases of H4, in all the cases of adjustment of status EAD, where the EAD is not approved, and the rule says that you can only file 6 months in advance for the EAD extension. Now, what do you do at this point of time? Can people file an EAD extension more than 6 months? Um, what I'm suggesting right now is go ahead and file way before. Now, at the same time, file the second application within that 6 month span. Let's say, for example, if your adjustment of status EAD is expiring in November of 2026, go ahead, file the extension right now. And they're giving it for 5 years. And be on a backup plan so that you can file one other application within 6 months. If just in case the one that you filed before get denied, you have a backup plan that the second one will be. What do you say, Rebecca? Is that a correct statement?
Yeah, I would tend to agree. I mean, at most, you're at risk of losing the filing fees, but if your I-45 is filed, before the fee rule changed, you aren't even at risk of losing DHS filing fees if you just try to file early. I know in our office, before the auto extension policy came into effect, there were some periods of time when we were testing a bit how early we could file an EAD renewal application. I think one of the attorneys in our office filed like 8 months prior, and it got accepted and approved without a problem. I don't remember if
I
how.
have filed several of those things, Rebecca, and I have
Uh-huh.
no issues getting the approval. Now, this may even be applicable for H4 plus H4 EADs, where we have filed H4 and H4 EADs way before 6 months. We have got those approvals. Now, we just want to caution that just file this one, but file another application too, just so that if anything happens with this one.
Yeah, and for H4 EAD holders, still the best way to get your EAD as soon as possible is still to file concurrently with your H-1B spouse. If they're having an extension or a transfer or an amendment, anything filed, just file your H-4 and EAD along with that, even if your EAD doesn't expire until 2027 or something like that. The concurrent filing of all three together is still, in our observation, the surest bet for the EAD to get approved in a reasonable time. Not all the time, like the previous person who asked the question. Sometimes they do get separated and the H4 and EAD remain pending for several months after, but I would say more than half the cases definitely are still being approved all around the same time.
Anything else, Rebecca, before we close?
No.
Thank you very much for tuning. If anybody wants to consult any of our office people, you can block a time that is suitable to you. Our calendars are available online, and you can block a time that is suitable to you. Thank you very much for tuning.
Thank you.